I'm Rida Hosain, and today we're going to talk about the 27th Amendment to the Constitution. When the 27th Amendment was tabled, members of the Pakistan People's Party and the PMLN claimed that they were fulfilling an old promise of the Charter of Democracy. The reality, however, is different. At the heart of the Charter of Democracy was civilian supremacy and an independent judiciary. Today, the Charter of Democracy is being invoked to justify measures that subjugate the judiciary. Now, what exactly does the 27th Amendment do? The 27th Amendment abolishes the Supreme Court of Pakistan's constitutional jurisdiction. The Supreme Court has effectively been relegated to the status of a subordinate court that will decide routine civil and criminal matters. And even in the past, military dictators have not succeeded in entirely stripping the Supreme Court of its constitutional jurisdiction, but through the 27th Amendment to the Constitution, the highest independent apex forum of the 1973 Constitution has been stripped of its most significant power. A federal constitutional court has been created. The first Chief Justice of the Federal Constitutional Court will be appointed by the President on the Prime Minister's advice. This is an executive-appointed Chief Justice. The first batch of judges of the Federal Constitutional Court will also be appointed by the President on the Prime Minister's advice and in consultation with the first hand-picked Chief Justice. This court, the first batch of judges of this court, including the Chief Justice, are executive appointed. This is not an independent forum. It cannot be classified as an independent forum. And the 27th Amendment also states that the Federal Constitutional Court will not be bound by any precedent of the Supreme Court. So Supreme Court decisions are binding on all courts except the Federal Constitutional Court. This leaves the room open for the Federal Constitutional Court to change precedent that has been well established in our jurisdiction for years, and effectively the Federal Constitutional Court is given a clean slate and has been given the opportunity through this clean slate to set their own precedent. The 27th Amendment also states that judges can be transferred from one jurisdiction to another without their consent, and the transfer will be done on the recommendation of the Judicial Commission of Pakistan. The Judicial Commission of Pakistan is no longer a body that is controlled by judges. The judges have been rendered a minority on the Judicial Commission of Pakistan, and there are executive government members on the Judicial Commission. And the result of this is that government members would be involved in deciding whether a judge should be transferred from one jurisdiction to another. And as I said, the requirement of a judge's consent for transfer has been removed. If a judge refuses a transfer, proceedings in the Supreme Judicial Council will be initiated, and a judge can be removed on the basis that he refused a transfer or she refused a transfer. And at the heart of judicial independence, at the heart of security of tenure, lies the fact that judges must be free to decide without fear, without favor, and without external executive influence. If judges fear that they can be transferred out of their jurisdiction because of their decisions or because of the votes of government members, they will fear punitive transfers, they will fear retaliatory transfers, and this will impact independent decision making. It can also be used as a tool by the executive to discipline inconvenient judges, and it is entirely inconsistent with the principles of security of tenure, which mandate that a judge cannot or should not be removed for reasons other than misconduct or incapacity. And so the 27th Amendment introduces a new way for removing judges and for disciplining judges that the executive finds inconvenient. The 27th Amendment also introduces provisions which relate to lifetime immunity for certain unelected officials, and this results in a fundamental shift in the constitutional balance of power, because democracy cannot exist with permanent impunity. And post the 27th Amendment, 3 judges have also resigned: Justice Mansoor Ali Shah, Justice Athar Manila in the Supreme Court, and Justice Shams Mahmood Mirza in the Lahore High Court. Justice Mansoor Ali Shah, in his resignation letter, has said that there is no constitutional basis, no legal necessity, and no jurisprudential foundation for the 27th Amendment, and that the 27th Amendment is simply a way to place the judiciary under the executive's influence. He has called it a dangerous regression and said that in the presence of the 27th Amendment and in the presence of the fact that the court has been stripped of its constitutional role, he will be unable to fulfill his oath of office and therefore resigns. To talk about the 27th Amendment in more detail, we are joined by Salahuddin Ahmed, who is an advocate of the Supreme Court and the former president of the Sindh High Court Bar Association, and we will ask him whether he thinks that under the 27th Amendment, whether the judiciary in Pakistan is still independent or whether the 27th Amendment is the final nail in the coffin of an independent judiciary in Pakistan. Sir, if I can first ask you, is the judiciary in Pakistan still independent after the 27th Amendment, or is this the final nail in the coffin of an independent judiciary?
I don't believe that we can lay any claim to having an independent judiciary after the passage of the 27th Amendment. I think a mortal blow was already dealt by the 26th Amendment through the creation of constitutional benches effectively selected by the executive through the Judicial Commission, which they dominate. Now, after the Federal Constitutional Court, which is basically it is sits above the Supreme Court in the hierarchy of the judiciary now. That federal court will have its first batch, at least, will be of judges. The Chief Justice and the first batch of judges will be selected directly by the Prime Minister. It's really telling that they did not even trust their own Judicial Commission to select the first batch. That will be done personally by the Prime Minister, which makes it clear what kind of court that would be. I would consider it just a kangaroo court meant to rubber stamp and endorse everything that the executive does. So, yes, I think, to speak of an independent judiciary in Pakistan is, it's just nonsense.
And there's also provisions in the 27th Amendment which say that this new federal constitutional court will effectively sit over the Supreme Court and its decisions will be binding on the Supreme Court, and it's relegated the status of a Supreme Court to a subordinate tribunal that will just hear routine civil and criminal matters. How do you look at this from the perspective that our precedent, which has been established for decades with regards to certain issues, this federal constitutional court, it leaves the room open for it to change precedent that has been established for years in our jurisdiction?
Yeah, so one of the big problems that happens when you create kangaroo courts is that if you don't free them from the burden and shackles of precedent, then they are much less effective in endorsing whatever you want to do. So it was, of course, necessary to free this federal constitutional court from any of the restraints of any prior precedents of the Supreme Court. Even previously, of course, when there were genuine changes, for example, when you formed the Supreme Court in 1956, etc., the Supreme Court would consider itself, they would apply and adhere to previous decisions by the Privy Council, etc., prior to 1956. Obviously, that would have been inconvenient. So the amendment categorically says that the orders and judgments of the Supreme Court shall not bind the federal court, whereas the judgments of the federal court shall bind the Supreme Court. So the Supreme Court is, of course, no longer supreme, and it is the federal court that shall do whatever it likes.
And in addition to that, they've also said that they have the ability to transfer judges from one jurisdiction to another without their consent. And this raises concerns about judicial independence because judges will now constantly fear punitive transfers, retaliatory transfers, and that will cloud their decisions potentially, that if they fear that tomorrow we can be subject to a transfer because of our jurisdiction, because of our decisions and shifted from our jurisdictions, that has the ability to impact independent decision making. Do you think it's consistent with judicial independence to say that judges can be transferred from one jurisdiction to another jurisdiction without their consent? Previously they introduced a provision which said deemed retirement if they don't consent to the transfer, but now they've sort of tried to water it down or presented it as a watered down version, that proceedings will be initiated in the Supreme Judicial Council. But this also leaves the room for judges to be removed on the basis that they refused a transfer.
So these kind of transfers, they were initially introduced in the Constitution of Pakistan for the purpose of controlling and coercing the judiciary. It was done during the Bhutto regime. That power was in the fifth, sixth amendments. That power was expanded by General Zia. Thereafter, after the 18th Amendment, it was required that you had to get the consent of judges because without transferring somebody without their consent was obviously a coercive measure and it impaired the independence of judiciary. Um, because these transfers were made in the Islamabad High Court, certain transfers were made, and it was desired that the judges who were creating problems for the government should be removed. So this clearly malafide exercise of legislative power has taken place, and the purpose is, look, for the bureaucracy, the most effective tool for the government, for the political government, to control the bureaucracy is by using the powers of transfers and postings. That's how they control the bureaucracy. And that is exactly how they wish to control high court judges now. And that's why this provision has been brought in.
And in addition to that, they've also retained deemed retirement for one aspect. They've said that if a judge is offered appointment to the Federal Constitutional Court and they refuse appointment to the Federal Constitutional Court, that judge will be deemed retired. And appointment to the Federal Constitutional Court requires a fresh oath of office. And if judges refuse to take that fresh oath of office, they will effectively be retired. This seems more like forced removal, and it seems inconsistent with the principle of security of tenure.
Of course, it's a clear violation it's clearly inconsistent with Article 209 of the Constitution. It's inconsistent with the principle of security of tenure, which is the cornerstone of judicial independence. And the purpose is very clear. If they don't like a judge somewhere and they want to get rid of him, so they just offer him a seat on the Federal Constitutional Court, and they expected, I think, that some judges would resign after the 27th Amendment. And they felt that perhaps any judge who doesn't resign, we can always get rid of them by nominating them to the federal court. And if because I mean, many judges, they apprehended that because many judges consider the Federal Constitutional Court, the creation of it, to be inconsistent with their oath to defend and preserve the Constitution. The government and the party, the establishment felt that perhaps this is a way through which we can get rid of inconvenient judges.
And if I can finally ask you also about the principle and concept of lifetime immunity, which they have included. And this is for certain unelected officials. They've said that they shall have lifetime immunity from criminal prosecution. And we've seen that even in times of dictatorships, when dictators have sought to immune themselves from action by the courts or to protect their actions or martial law actions from judicial scrutiny, that immunity has also been a time limited immunity. This amendment seeks to make immunity absolute, permanent, and even post office, they have said that this immunity will be there. How is lifetime immunity consistent in a country that claims to call itself a democracy when you're effectively creating classes of individuals that will be above the law?
So the idea of immunity comes, of course, from monarchy. The king can do no wrong, right? In absolute monarchies, you had that principle. In democratic countries, there is a certain limited immunity given to office holders of high office in the performance of their functions, right? You never have a situation where, the president of the United States can't go and kill someone and expect to have immunity, for his lifetime. That's just not the way democracies work. But I think the changes to Article 243 and 248 are actually more fundamental than that. I think they completely erode the idea of civilian supremacy in Pakistan. When you appoint a field marshal for life, when you say that he cannot be removed except by a two-third majority in parliament, that makes him effectively unaccountable to the government to which, in theory, he should be answerable. When you say that even after his term as army chief ends, he may be asked to carry on such duties as the government may consider appropriate in the national interest, you are basically setting up a lifetime office holder. And in the Pakistani political context, you are basically opening the door to a lifelong dictatorship. And then, by further granting him lifetime immunity, civil and criminal, for any of his acts, I mean, I can't think of something that is more against the principle of rule of law. And of course, once such a great honor was being bestowed, then, at least one of the political parties thought, why don't we hitch our wagon to this train as well and get the same kind of immunity for our president? Thankfully, the other party, resisted that temptation for the prime minister. But it just makes a mockery of the rule of law, and this whole the changes to Article 243 are basically setting up an unelected lifetime ruler of Pakistan.
So we've talked about how judicial independence virtually stands obliterated, how it's compromised the authority of the sitting civilian government and given lifetime immunity, which is inconsistent with basic fundamental democratic principles. But you have members of the government going on television and saying that the parliament is supreme and that the parliament has the ability to do anything. And they refer to Article 239 of the Constitution, which they've also now amended to say that the courts will not question the constitutional amendments and that the courts are unelected and it is the parliamentarians who are elected and have the authority to make changes to the constitution. But even Article 239 in the constitution, which seeks to prevent on the face of it the courts from questioning it, it was added first by a dictator. Ziaul Haq added Article 239 to the constitution to shield his distortions, I would say, to the constitution constitution. And now that article is further being amended by the present government and has now been amended by Parliament to shield their own constitutional amendment and to prevent it from being judicially reviewed. In the presence of this Article 239 that they've now amended, do you think that there is still authority with the courts to strike down constitutional amendments?
Look, this concept that the parliament is supreme, I mean, I really feel that it needs to be laid to rest. Okay. I mean, it keeps on being trotted out either with people with a deliberate agenda or with people with an insufficient understanding of constitutional jurisprudence. Okay. The parliament is not supreme in any constitutional democracy. It is the constitution that is supreme. The parliament is conferred certain powers in constitutional democracies. This idea of parliament being supreme stems from, old English law, right? And as you know, in Britain, they don't have a constitution, at least not a written constitution at all. And that's where the idea springs from, right? But in all countries with a constitution, the very purpose of constitutions is to fetter the powers of all the other instruments of state, including the judiciary, the executive, and the parliament. There are certain limits placed upon their power. Now, the amendatory power of parliament, that is, of course, there are certain, limits to that amendatory power. And one of those limits is, for example, and I don't want to get into that whole debate about the basic structure, doctrine, etc. But one, there is a procedural limitation that Parliament cannot. Let's say, for example, the Constitution requires a two-third majority for a bill to pass. The Parliament cannot pass a law saying we are supreme, so we are now going to pass a constitutional amendment with a one-third majority, right? That's a procedural limitation. Then there's a substantive limitation that Parliament cannot, for example, say that, look, like the field marshal, we will also stay here for life. And after us, our children will inherit our seats for parliament. That is a substantive limitation on the power of the parliament. They cannot change the structure of the constitution, right? So, like the basic structure doctrine itself, it was invented in India, but it has been followed by dozens of countries, ranging from Belize all the way to Taiwan, right? So anyway, that's there. Now, as far as this Article 239 is concerned, it was, of course, introduced by Ziaul Haq to protect the Eighth Amendment, preventing the courts from looking into constitutional amendments. And but even after Zia's introduction of this, Article 239, the changes to it that prevented the court from looking into these matters, even after that, in various judgments and most recently in the Rawalpindi District Bar Association, the full court of the Supreme Court held that yes, so long as the parliament is exercising amendatory powers, we will not look at the amendment. But if the parliament goes beyond mere amendments and changes the essential features of the Constitution, it changes the federal model of government, it changes the democratic model of government, it impairs the independence of judiciary. These are such essential features of the Constitution that these are not mere amendments. This is akin to creating a new constitution, and the parliament is not a constituent assembly. The parliament is bound by and the amendatory powers of parliament are bound by the limits imposed implicitly and explicitly by the constitution itself. So, that case law is there. The principle is clear. Whether the federal constitutional court would apply these principles, I wouldn't hold my breath.
Thank you so much, sir, for your time. I think that it's really important for us to break these narratives, especially that the government representatives are trying to use to support this amendment to say that effectively they can do whatever they want because the parliament is supreme. As you've said very rightly, in our jurisdiction, the parliament is not supreme. The constitution is supreme. And even in district bar, as you mentioned, 13 out of 17 judges held that the court has the power to judicially review constitutional amendments. And as you said, while there isn't much hope with this new federally constitutional court, controlled court, kangaroo court, whatever we may call it, I think that one must never lose hope. And at least there is a possibility that these amendments, that various challenges have been filed and more challenges may still be filed to resist the 27th Amendment to the Constitution. Thank you again for your time.